Hi, I'm attorney Gregory Dell, and I'm here with attorney Stephen Jessup, and we're going to talk about disability insurance denial reasons. And a lot of people have contacted us over the years, and we've seen every single type of basis for a denial. But I want to go through a series of videos that we're going to do where we're going to get into some of the top denial reasons that we see and hopefully provide some tips that people can understand what's going on in the process that may lead to a denial, and hopefully pick up some advice that may help them to avoid a denial. So the first type of denial that we most commonly see has to do with medical reviews or IMEs, which are independent medical exams requested by the disability insurance company. Let's discuss what those are, what the disability insurance company is doing, and what a person should expect when a claim is denied based upon a medical review by an insurance company.
Yeah, so first, we're looking at those different options that they're going to use in doing a medical review. The most common that you will generally see is some type of file review. Whether they're going to have their own internal doctors take a look at it, like a medical director, to determine if you are, have restrictions and limitations, or if they hire an outside doctor through one of the companies like ECN or something to do a file review. So they're not going to examine you, they're not going to speak with you, they're just going to take a look at what's in your medical records and determine if you have any restrictions and limitations. And it's not even going to be geared towards what your occupation was or some idea of another occupation. They're just going to look, do these medical records support restrictions and limitations? If no, it goes on to further review. So it's a very cold process, and more often than not, you're not even aware that this is happening. You may not find out it's happening until you receive something from them about it. And then the other type is obviously the independent medical evaluation, where they will contract with a third-party vendor to find a doctor to do a physical examination of you, or if it's mental health, to do some type of mental health or cognitive evaluation as an impetus to try to look to determine if you continue to meet the qualifiers for disability under the policy.
So, Stephen, how or can they legitimately not even speak to the claimant, not speak to the claimant's doctors, and just look at medical records and based upon that alone determine whether or not a person's able to work? How can they get away with that?
That's the million-dollar question. I mean, the short of it is they do. Because in the initial denial, if they're using this review as a denial, at that point the stakes aren't in court with this idea of what the standard review and how they acted in the review. They're looking for the lowest common denominator to figure out a way to deny you, in my opinion, to see if you're going to bother putting up a fight. And if they're wrong, then they put you back on claim, they pay you the money they owe you, no harm, no foul kind of thing. I think that's why, too, early on in some claims, you can see denials on short-term disability claims where it's just a nurse who is basically overriding your doctor's opinion. Is it right? Not at all. Is it inappropriate? In my opinion, yes, but they are allowed at this threshold to rely on a file review. There are court rulings that say, hey, you can rely on a review done by a doctor of the file without examining the insured at all. So they are allowed to do it. So that's why it's always important. We like broken records. We talk about the strength of your medical records, because you may only be evaluated not on you as a person, but what you are displayed as in your medical records.
Now, you mentioned that they could use a nurse. Are they not required to use in an initial review the same type of doctor to review a claim that the claimant was treating with?
What I find is a lot of times what they'll do is they'll do a generalization. A nurse may come up with a decision, it goes to a medical director. A medical director may be internal medicine, and you don't necessarily see where they get specialists involved in initial denials. On an appeal, once you've done an appeal, then you almost always see them get a specialist involved. Not always, almost always. But generally speaking, you don't see too many specialist reviews early on. Unless it's a mental health claim, then they will defer to a mental health specialist.
Another question about the paper medical review. Can the disability insurance company use their own employees, or can they use some third-party outside company to review the medical records?
Both. Sometimes they will use both. They'll use their own medical directors or in-house doctors to review it. And then, if they're building up their arguments for later, if you end up in court, they will send it to outside doctors. but you see each insurance carrier will have their own kind of way of doing things. But yeah, they could do it solely based on their own doctors who they employ's opinion, or they'll base it on, when they hire an outside doctor to take a look at it.
And in terms of using an outside company, some disability companies say, we use this outside independent company to review the medical records. Do you find that those companies are really independent?
I mean, independent as they don't work for the company, but independent as to what? There's always this argument that, a lot of times, one thing I like to do too when I see a doctor who's done a review is going to do an IME is a simple Google search. And I think one of the biggest red flags is if you do not see that this person has a general practice, that they actually treat patients, this person makes their living doing exams. You can Google these doctors and find that that's what they do. That's how they make their job, is just doing medical reviews and the thousands of reviews they've done and all their expert testimony. So you know that they're a hired gun for the insurance company. Independence is always kind of a strange thing. Now just to play, both sides of it, I have seen where claims have been, during the appeal process especially, the insurance company says, well, we're just going to send it to an independent medical evaluation to make the call, to split the tie. And I have had it where IMEs have come back in favor of the insured to the detriment of the insurance company. So not every IME doctor or even peer review doctor is going to just side with an insurance company. But there's always a level of skepticism when you're going to an independent third party. And even the insurance companies, they will argue, well, your own client's doctors aren't independent. They have a vested interest in your client because they treat them. So it's this kind of back and forth. But I think researching the doctors who've done the reviews, or who you may have to go submit to an examination with, doing some research on those doctors can give you a much better idea of what exactly you're dealing with in this idea of independence.
And then those are great points when you're talking about the specific doctor, if you're being requested to go to an IME, or if there was a paper review, looking up that doctor. And then also, we could do legal research and you see these doctors quoted in the lawsuits. Yeah. But also, Stephen, these third-party companies I find are not independent, like Gen X, MCE, all of these different review companies that work regularly with the disability insurance companies get paid hundreds of thousands of dollars a year, if not millions, to find doctors to do reports for them. And even as of recently, I know we see a lot of denials, but the Gen X reports have been absolutely ridiculously skewed in favor of finding that the claimants have no limitations whatsoever, when you have claimants that have 4 or 5 doctors that say they're disabled, and some severely disabled people. So it blows my mind how they find, it's one thing to be a company, but then to find all these other hired doctors who play along with their theme of look for any reason to say the person isn't disabled. It's not independent when you keep going to the same company to find doctors to review the claims. And then the last things along this category was the independent medical exam. And certainly I would encourage people to watch the videos where we've talked about how to be prepared for these independent medical exams, what to expect, what you should or shouldn't do, and how the disability insurance company is going to use the exam of the claimant. And then, also, Stephen, the fact that you have the opportunity under the new ERISA laws to reply to these paper reviews or these independent medical exam reports. And how do you handle that situation in terms of replying to a report that already isn't favorable to whether or not the claimant's disabled or not?
Yeah, so there is the new regulation there. My personal opinion, if you're going through an appeal process and you get those reports, more often than not, experience will show that the insurance company is going to deny the claim. They're just abiding by what the requirements are under ERISA. And then later on, and if there is a final denial of your appeal, they even talk about, we gave your doctors the opportunity to respond, they didn't respond, or it didn't change our opinion. So they're working towards this, standard of review of arbitrary and capricious and reasonableness and these things. But it is very important when you get those responses to coordinate, and they don't give you a lot of time, with the treating physicians to respond in full to the various points that are being made. We've had success in even getting those reports and the rebuttals from the doctors changing and swaying the opinions, which is difficult because ultimately you get those reports, you get it to your client's doctors respond, where those responses go back to the doctors who just said you could work. So now it's a matter of your doctors being able to persuade these doctors that no, your opinion is wrong. It's definitely an uphill battle. This regulation change seemed like it was something that would be in favor of the insured. And in a lot of ways, I think it just helps build up a record for the insurance company if it goes to court. Not to mention the insurance companies then are putting reviews on hold. So the deadlines with which to finalize your appeal decision becomes even murkier because you're waiting for responses from doctors. They'll say we're going to toll this period until such date, or we have your response. So it can cause a lot further delay and build up the strength of the insurance company's opinion more. So if you were going to win, you wouldn't even get those reports. So you got to be very, very careful. And we've seen a big influx in calls where people are like, hey, I've been denied. Cigna's probably the best because the way that they do it with their doctor's reports, they start by saying, we've reviewed your appeal, we've decided our decision was correct, and then you got to read down and say, but we're going to allow you to respond to these reports. So people contact, say, hey, I've been denied, I get the letter, I go, oh no, you have 3 days left to get your doctor to respond to these, and time is of the extreme essence at that point, because that's your last bite at the apple at that point before potentially having to file a lawsuit.
And Stephen, along the lines of what you just said, that whole scenario is even more complicated when you have these companies in the initial review of the claim who say, we hired a doctor to review your claim. Here's what the doctor's saying, which obviously isn't favorable. Do you want to comment? Now you're stuck in a rock and a hard place, because what do you do when you comment? You have your doctor's comment on the initial review. They're still going to end up probably denying the claim. Now you have an appeal. You're really limited now on what your strategy is going to be in the appeal, because you're just going back to the same doctor initially when you're going to have to do it all over again in the appeal. So while you do have that option in initial review prior to any denial, I often defer on that and just say, please make your decision based upon the records, because we already know they're going to deny it, and we got to save our ammunition for the appeal to be able to come up with something new and to get away from that doctor already who probably can take the information that the treating doctor is going to provide, further support their position, and just make it that much harder in the appeal. So that's a strategy and judgment call basically, in every case, whether it's initial review of the claim or you're during the appeal, as to how you want to respond to these file reviews or independent medical exam reports. So in summary, clearly the file review independent medical exam is one of the top reasons for a long-term disability denial. If you've found yourself in this position, feel free to contact Stephen or myself. We'll provide you with an initial free consultation and review of your claim. We're available to represent you all over the country, and we look forward to the opportunity to speak with you should you need us in the future. Thank you.